Republic versus Cojuangco, GR number 139930, June 26, 2012. This is for criminal procedure, specifically criminal actions how instituted. Subtopic: Interruption of the running of prescriptive period. What is the effect of the institution of the criminal action? The institution of the criminal action shall interrupt the running of the period of prescription of the offense charged unless otherwise provided in special laws. What is the rule on prescription in case of institution of a criminal action based on special penal laws? Prescriptive period for special laws is interrupted by the institution of proceedings for preliminary investigation. Facts. This case was about the application of the rule on the interruption of the prescriptive period in the recovery of alleged ill gotten wealth. This was an original case for violation of Section 3, Paragraph E of Republic Act Number 3019, filed by the Office of the Solicitor General on March 1, 1990, before the Presidential Commission on Good Government against respondents. During that time, the prescriptive period for the said offense was still at 10 years. Allegedly, the respondents, collectively referred to as 1979 members of the United Coconut Planters Bank or UCPB Board of Directors, entered into an investment with Unicom Corporation, allegedly owned by respondent Cojuangco, supposedly a Marcos crony. Said investment was allegedly, manifestly, and grossly disadvantageous to the government. The PCGG referred the complaint to the Office of the Ombudsman since it had been disqualified from conducting the preliminary investigation in such case. The Office of the Ombudsman dismissed the complaint on the ground of prescription. It ruled that UCPB's subscription to the shares of stock of Unicom on September 18, 1979 was the proper point at which the prescription of the action began to run, since Respondents' Act of investing into Unicom was consummated on that date. Thus, the period of prescription began to run at that time, while the complaint was only filed on March 1, 1990. The motion of reconsideration was likewise denied. On appeal before the Supreme Court, the petitioner argued that although the charge against respondents was for violation of the Anti-Graft and Corrupt Practices Act, its prosecution relates to its efforts to recover the ill gotten wealth of former President Ferdinand Marcos and of his family and cronies. Section 15, Article 11 of the 1987 Constitution provides that the right of the state to recover properties unlawfully acquired by public officials or employees is not barred by prescription, laches, or estupel. Petitioner pointed out that assuming the offense charged is subject to prescription, the same began to run only from the date it was discovered, namely after the 1986 EDSA revolution. Thus, the charge could be filed as late as 1996. Issue: whether the respondent's alleged violation, Section 3, Paragraph E of RA 3019, in relation to the government's efforts to recover the ill gotten wealth already prescribed. Ruling: yes, the respondent's alleged violation of Section 3, Paragraph E of RA 3019 in relation to the government's efforts to recover the ill gotten wealth already prescribed. Under the existing jurisprudence, Section 15, Article 11 of the 1987 Constitution applies only to civil actions for recovery of ill gotten wealth, not to criminal cases such as the complaint filed against the respondents. In this case, RA 3019, being a special law, the 10-year prescriptive period should be computed in accordance with Section 2 of Act Number 3326, which provides for the two rules on determining as to when the prescriptive period shall begin to run. First, from the day of the commission, the violation of the law, if such commission is known, and second, from its discovery, if not known, and the institution of judicial proceedings for its investigation and punishment. In this case, the Supreme Court said that the applicable rule should be the first rule, since the information on the subject investment was publicly accessible and did not appear to have been withheld from public knowledge. Here, the alleged violation of the offense charged was committed in 1979. However, the complaint was only filed in 1990, which was clearly outside of the 10-year prescriptive period. Therefore, in applying the foregoing, the Supreme Court denied the petition.